All right. We're going to start off with the legal side of programming. My name is Amy Barnes, and I am the notorious Amy B in Cobb County. And I'm not a lawyer. I cannot say that enough. I'm not a lawyer, but I have litigated from magistrate court all the way on up to the Supreme Court of the United States of America and got docketed. So I know a few things. And I work at law offices, and I have been working with several law offices since, I feel old now, 2010. I happen to be also a programmer since 26 years ago. I can't calculate that. So that's a long time ago. And my experiences in seeing case law has prompted me to offer my experience and understanding matching programming with the legal side. And many people don't understand the ramifications that programming can have legally. Now, today's focus is mainly on contracts, how they function, but also how contracts carry certain requirements specifically because of how unique software development is. Software development is not where you go and say, I got a cow for sale, $2,000. It's not like that. It intersects with several different types of law, and it does impact contracts. And let me see how to go down. All right. I am legally required to disclaim by law, because I'm a notary, I am not a lawyer. None of this is legal advice. For legal advice, seek out a lawyer in your jurisdiction. A background and experience, simply put, I have over 10 years without a lawyer of litigating and beating actual lawyers. I have set precedents at law for the First Amendment, that's free speech here in the United States. I have set precedents at labor law, ADA rights. I forced a law library to be moved to avoid litigation for ADA rights. I am the reason why a lot of policies have changed from police policy and court policy. I'm the first person to have e-filed in certain courts. So that's just a tiny bit of my background, and I work with several criminal defense firms here not here, but in Metro Atlanta area. Some of the most high-profile cases on the news, I have been pulled into those defense teams to do work for them, and I have done a few things for the ACLU. Okay, contracts. When we think of a contract, what do you think of? You think of a long, expansive document, maybe something written on a napkin? But how about just a handshake and an oral promise? What if we wrote it on the side of a cow? Yes, that's literally happened in the state of Texas. So a contract can be any of those, but software programming, because of the complexity and the nature of it, there is almost a requirement to be definite and certain and be in writing. Now, when you're shooting it on email and you're just commenting and throwing out, hey, I can include this, or hey, here's I can do database. Unless you specify, we are only going to do X, Y, Z, like a friend of mine, you may be held to all of the above. So with contracts, there are a few main pieces. There are the parties. That means who is dealing with whom. Now, that does have an impact. If you're a developer and you say, hey, I'm going to go under my name, you actually have fewer constraints than if you did it as a corporation, whereas in terms of liability, you would have everything on the line if you were doing it in your name, versus a corporation, you'd be somewhat shielded. So this is why the parties to a contract are very important. There's actual case law in Georgia that a judicial decision just came out a few months ago in a civil case where the judge said, well, Mr. Defendant, you and your company are getting sued, but your company is required by law to have an attorney. And without an attorney representing the company, you may be found in default. Eventually, the guy lost because, well, he wasn't very smart. He didn't do things the judge told him. So, jurisdiction. You may be saying, okay, we're all here in Tennessee. And if I'm in Tennessee and somebody from the UK wants to purchase software from me, and we have a conflict, where is that going to get resolved? Now, you might think it's Tennessee, or you might even think it's the UK. But sometimes, due to the complexity of the law and your right to contract, you may opt for, say, I don't know, Delaware or New York law. So again, there is no such thing as a standard contract, and we must have definite and certain. If you are not defining the pieces of the contract, you're going to end up in hock or in trouble or in an additional fight. So you have your parties, you have your jurisdiction, you have your subject matter, you have the scope of the agreement. This is super, super critical in a contract. And you could end up theoretically being on the hook for many thousands of hours of work if you're not careful. And I learned this the hard way, starting out doing web design. I said, website, $1,000. How many revisions does that include? Well, I didn't specify that. So I spent probably 10 hours with someone presumably named Karen looking over my shoulder and henpecking me for every different font of something like 200 fonts she had me go through. So this is why we declare in our contract exactly what we are going to do, and we define what we are going to do. So a revision, what is a revision? Well, if you define it as a change, well, that change may take 13 days of work to process it. So you want to determine how many revisions. Specify that. You can always over-deliver. But the key here is to promise a minimum or a certain amount, and then if you feel like it, deliver above that. Otherwise, you'll be on the hook. Now, what this means is if you say, well, we can do your database, but you don't declare it in the actual contract for services, or you don't agree to exclude or include, you might be on the hook for 80 hours of work creating a whole database. We don't know. It's up to the courts or whoever, negotiations, all that. So another part of the contract that we have, one of the most critical parts, one of them, is your disclaimers. Okay? A disclaimer, you think it'd be obvious if your third-party servicer hosting service failed, you wouldn't be on the hook. No, necessarily. There's a software developer who back in 2013 built gambling software. I think Robert Stewart, I believe is his name. He built gambling software. Okay, so he built the software. He didn't realize that New York mob was going to go in and use his software to gamble in New York. Well, this poor man ended up getting criminally charged because he did not say, hey, we can't do anything illegal up front. This is not for any illegal purposes. So just claiming the failure of a third party thing like a hosting service. If hosting service fails, I'm not responsible. If you do not disclaim that, they can go to court and claim that you bought liability for that. If you do not disclaim that your software is not to be used for any illegal purposes, you might buy the farm. They could always claim you bought the farm. Then it's up for you to fight. So, I'm not a lawyer, and what I suggest for everyone to do, if you own, operate, have any kind of signature authority at all to do a contract, get an attorney. Get a contract in order. Look at all the four corners, every corner of your situation, because the attorney might see problems on the horizon that you would be completely blind to because you're not in law. So contracts, they intersect with different types and areas of law depending on what you are doing on that contract. So a big one here is our intellectual property law. If you're doing work and you got this software platform under contract, and let's say your customer is using your software to interact with their customers, so it's kind of like a white label product. Well, the intellectual property consideration is where you have to say, hey, I'm not responsible for user content. This is where we get the likes of Facebook and Twitter, mass media companies, news media. We're not responsible for the comments our users post. So if you disclaim up front and you build in the disclaimer, I'm not responsible for my users. The users can be held accountable, but I can't buy the farm. And so one way to deal with this user-generated content is to allow moderation features. That is a consideration. But intellectual property, you may actually have an interest in the software. So one of the considerations that you have to take into account is, what if your customer gives you this great idea but doesn't pay you, and now you have this software? That's one of the things you might want to consider asking an attorney about to build into your contract. The thing is, when you look at a contract, it's not just a boring piece of paper. It is your sword, it is your shield. Your contract can protect you from amazing varieties of harm while giving you an opportunity to remedy things. And so we're going to get into that a little bit more later on. Special considerations. The software industry, I'm going to go ahead and make sure that I have all of, okay, I see where that is. So special considerations is, I originally had text on here and I was advised to trim down the text so people's eyes don't bleed looking at my presentation. But anyway, special considerations are those clauses, disclaimers, indemnities. I indemnify means either I am going to back this particular whatever this is, or I'm going to disclaim liability, or I'm going to declare this clause. And an example is if you use a service like Firebase or any other third party, and that third party is a critical component, I disclaim that if it goes down, I'm not at fault. if my client does something illegal, I'm not at fault. The client is going to adopt the responsibility. The client is going to indemnify and hold harmless. The client is not going to go after me for illegal conduct on the software because I notified them via the contract. So, and the other thing is, when you write software, you have to look at the tax, you have to look at the financial implications. I know there was a state here, each state has its own tax collection. So this is where if you go onto some of these online stores and you sell your iOS app or you sell your Android app, they automate the tax collection. But what happens if it's a desktop app or if it's a web app and you're not on those two very helpful platforms? How are you going to figure out who pays what taxes to where? Who's going to be responsible for that? That's something you might want to consider addressing in your contract. Another special consideration is the ADA. You realize as a software developer, you're creating a product that's going to be accessible to the public. And it has happened. People have been sued because their software did not contain enough accessibility features or it didn't use accessibility features. So if something comes out and something is new, a new feature, that you can't be held responsible for what you weren't paid to do, all right? So if somebody tells you build the software, but they don't tell you about this entire framework necessary for accommodating the disabled, who's on the hook for that? And you might go, oh, so what? Well, there is a group of people from Florida who are in wheelchairs, and all they do is they go around and they find businesses that have slight ADA problems, and they tell their attorney to kick out another demand letter. So these people have raked in millions of dollars of brick and mortar businesses. I have bad news for you. They're now looking at the software. They're now looking at websites. That's a lot of money. So special considerations, ADA, accessibility, is a huge one. I'm mostly deaf. You wouldn't know it. I'm very visual. I see things. I watch things. But if someone's blind and your software does not work with screen readers, you might want to disclaim liability if your client is not going to pay you for that. So the ADA is a consideration due to increasing litigation against websites and now app. And I know Uber suffered a lawsuit because of dogs being denied access to the cars. But anyway, so preventing fraud is a particular consideration. There's a new scam on the front, dealing with contracts. There's a brand new scam, and one of the attorneys I worked for actually received one of these phishing fraud attempts. And what it is people are now targeting high-dollar occupations such as attorneys, software developers, independents. You name it. If it's got a lot of money changing hands, if it's expensive, they'll try and do the refund scam where they send you a $5,000 check and a $3,000 estimate. And, oh gosh, I overpaid you. So, just a bit about preventing fraud on contracts. When you get that message, that inbound message saying, hi, I'm Company Joe. I'm the president of this company. I need some software. You're my person. Did you look up to see if the company was registered? Did you check the Secretary of State database? Did you check that country, if it's from a foreign country, database? Did you check and see if there are multiple references to the company online? Well, the scam I saw was quite convincing. $300,000 for medical imaging, and well, it was a fraud because the company never existed. But the CEO wanted to send a check. Well, they're doing that to businesses such as software developers. The other thing about fraud is KYC and AML. So KYC is know your customer. Now, if you are dealing with any kind of money being transferred or any kind of money being paid out, depending on the industry, there is a literal federal requirement to collect certain pieces of data from your customer. Know your customer. So we see this particularly with cryptocurrency. We see this with third-party payment stuff, like pass-through on payment processing. Might be one of those required items. I don't know in full, but again, know your customer. AML, anti-money laundering. AML has different stipulations depending on the size and source of the money. So if you are developing software dealing with anything on money, you may need to build it into your contract for services, an extra fee, or consideration for fraud prevention. So that's just something to think about when you're giving out quotes for developing software. And this is, again, why you want to consider hiring counsel, because lawyers will be very quick to research and say, oh, you're obligated X, Y, Z, W. And they'll help you see over the horizon further than what you might be aware of. International law. Well, most of us think in terms of our own jurisdiction. But because software is global, your ability even to contract may be affected by treaties, embargoes, restrictions, sanctions. Who's sanctioned right now? So if you're here where I'm at currently in the United States, I don't know, but you may or may not be able to transact with someone from Russia or China or any of the countries that the United States is not necessarily seeing eye to eye with. Again, this is why software is so complex on a contractual level, and this is why you have to scroll down 11 years before you get to the end, before you can click to accept button on any agreement. It's because those people, the reason why they're so long is because every time they got burned or somebody got burned, they had to add in something. So contracts, the way they are made, they're not made necessarily out of preparation some of the times. They're made because somebody got burned and somebody had to pay. So international law, there are considerations on the contract for that. Preventing disputes. The biggest thing I can say is you want to have your remedies, your available solutions, a delay. What happens if the client delays on something and it affects your critical deadline? Have you considered what remedy is on the table for that ahead of time? What happens if lightning strikes your computer? Like it happened to me. Literally caused me to go into default on a contract because I lost 2 months of work and blew a deadline because lightning struck my computer. Whew. Well, I didn't realize that I needed an act of God clause in my contract. Well, c'est la vie. So this is why I'm telling you about acts of God clause, is because I don't want you guys, gals, whoever, to possibly end up in my shoe or shoes. Now, preventing disputes involves communication. So one of the things that we don't do is we don't get hot and heavy on the text or the email. Sometimes it's best to just ice it down, cool it down, just let it sit until you cool down. A lot of the disputes that I see, now I work with a law firm, so I see the inbound messages coming in. I want to sue. 9 times out of 10 times, people want to sue because they've been made to feel upset. Now, I mean, we think about a contract and we go, but the feelings? People get motivated. They get motivated to sue because they felt a certain way. So the way we prevent a dispute is we have remedies, we have communication, frank, to the point, non-offensive communication, early communication. And I'm dealing with a project right now for somebody's app, and somebody in the chain said, there's going to be a delay. So the earlier you inform someone that a delay could happen, doesn't have to happen, doesn't have to be guaranteed, but if you say up front, there might be a delay early in the experience, and not like, oops, we're delayed. If you communicate early, that allows everybody the time to come up with a solution. So people who sit on a problem and go, it's a problem, cause more problems. So when you're seeking to prevent a dispute, if something can happen, if you have a lawyer, let the lawyer know first. But think of potential remedies. Think of potential alternatives. At the hosting center, data center, like what happened about 5 months ago, I think it was a data center burned down. Oops. So how fast were the end users notified? That makes a big difference. So you might have a backup option and say, hey, we're going to have a delay here, but we're going to flip on over to this. So preventing disputes also involves planning ahead of time. So when you look at a job and you go through the contract, and you look at the job and you say, this hosting, well, what happens if that hosting goes down? Have you considered backup? What other hosts are available that are compatible? So when you frame out any kind of agreement, you want to put alternatives. You want to have a backup plan from the beginning so that you're not standing 3 sheets to the wind going, whoopsie, not a good look. And I've been in business since I was 9 years old. I'm 39. So 30 years of flipping candy and hustling and running businesses. Yes, I knew double entry accounting at 9. They hated me in accounting class because of it. So what I did is when I went into business, when I went into anything, I planned that sucker out 7 layers deep. And I knew that if I worked hard, my reputation is my work. If I have sloppy work, if something goes wrong and I look like I am, whoopsie, it's not a good look. So the whole point is to avoid looking like a tornado hit you and look ready to go and tackle whatever it is. Because your reputation is everything. Now that we have all these review platforms, it's a good idea to do the extra work. A stitch in time saves 9. Okay, lawyers. Collective chill. I think I'm going to vomit. No, just kidding. I work for them. We think of the sleeves and we think of the slime and we think of hands sneaking into our wallet. Wallet. So we think of that thing when we think about lawyers. But lawyers can potentially be your sword and shield. A lawyer has sat through law school, but again, like I said earlier, your work is your reputation, and that determines your future. So if you go online and you're searching for a small business lawyer and you see Shyster McCoy is a great guy, stay away. Don't choose that guy. Just don't, because you get what you pay for. I mean, for real. And a secret, I'll tell you my secret to finding, and now it's not a secret anymore. So between all of you and me and the NSA and I guess now the whole world, the right way to choose a lawyer is to literally look at their work, look at their history. Do they fight in court? Or are they like a limpy, like a little chihuahua that's all bark, and then as soon as you approach it goes, like an injured animal? There are lawyers like that who you look at the court record and you see they've lost. You want the lawyers that are on the court record. You can go into online court dockets. You can search for the lawyer's name and you might find news articles about big, giant settlement. Anyway, so if you find articles, expounding upon the lawyer's success, red hot, get him while he's available. Because as soon as they close the case, they're about to shift on to the next, and you have an opening. And I tell you another secret. There's not a secret anymore. You should be able to sum up your issue in 30 seconds or less. It's like jewelry. If somebody stands before you and starts a 5-minute spiel about their beautiful necklace, and you still haven't heard one iota of actual description, do they even sell jewelry? No, they have, get out of here. And that's how lawyers, they vet their clients too. And a lot of that is, where's the beef? So, for a business, what a lawyer is, it's either in-house, if you're seeking a permanent legal position that's in-house, or if you're seeking contract counsel, retained counsel, general counsel. And be prepared for the care and the feeding and the watering as a lawyer. That means charging for the lawyer, but really, what you're paying for is insurance in the event something bad happens. The whole point of a retainer is you're putting into a honeypot so that you have conversations with that lawyer. Oh, by the way, now if I did this illegal gambling, oh, don't do that. You're paying for that advice. Now, don't be certain people, unfortunately, who go, oh, thank you, and then do the exact opposite of what their lawyer says. Not good, but lawyers are absolutely worth it if you find somebody who can explain to you in a way that you understand what you should and should not do. And, I've even retained counsel for employment agreements. $400 for document review, worth every penny. And that's because I literally work for attorneys, and I can tell you that the well of misery in the legal system has no bottom. And the reason why there are so many miserable people is because they didn't do their homework, they didn't do the research, they didn't know enough, and most, they didn't get counsel. So again, I'm not a lawyer. As a business person, if you have any kind of signatory authority whatsoever, if you want to avoid liability, retaining counsel is a very wise move. And software development is fraught with problems. There are cases. I I testified in federal criminal court last week on Friday. And BitConnect scandal, you can look it up, BCC, BitConnect. One of the lead promoters just got sentenced to 40 and some change months in prison. And I found out, guess who they might be going after next? Oh, the software developers. So again, retaining counsel and running things by even just one or two attorneys might save you from a prison sentence, because many times that there is a problem like that. The software developer either wasn't aware and needs to build up their defense. And like my husband, who was a hockey player, the best defense is a solid offense. Schmack. You get your evidence and you go schmack. And they go, gah, and have to walk away from the case. I've literally gotten 18 people out of criminal charges with just a single question. But anyway, so in conclusion, when you're dealing with contracts, you have the option of looking at existing contracts. And I'll tell you another secret briefly, is much of law involves 3 keys on the keyboard, and 2 key combinations specifically. Control-C, Control-V. Beautiful, but it's the truth. But what you're paying for is where the Control-C comes from and where the Control-V goes to, much like the mechanic who charges $10,000 to show up and turn a certain wrench a certain place and all that. You're paying for the experience. So, in conclusion, it's horrifically complex, but you have a ton of options out there, and before you set foot in that landscape, you need to realize it's not a landscape. There are mines under that landscape. So, anybody have any questions?
So, understanding that software contract law is kind of a specialty, and is there a way to determine
how do you find a lawyer?
What attorneys are specializing in that type of contract?
Okay, so for the record, how do I find an attorney who does contracts for software companies? Well, okay, you can look up the software companies in the docket and see who's sued by whom. And you can find out who that counsel was that represented the company. If they won, they're a good one. If they lost, well, maybe they had a bad case. But you can also look in the bar, and the bar typically has a directory, or you can find online attorney directories. avvo.com is it's built out as a forum, but they do have listings of attorneys, and you'll see if their profile says breach of contract or software or intellectual property, those people tend to be more in line. So you can always also search software development contract attorney, because Google goes through lawyers' websites. And the lawyers who really are dedicated to that will put the keywords in their website. Fisher Broyle is a good all-purpose law firm. They have their virtual firm, but they do have software-oriented attorneys. They have intellectual property attorneys. You really want to find the attorneys with software and contracts in their website. Might be under a separate heading. Intellectual property, software, contract. They all tend to float in the same, they all tend to rub elbows. It's kind of a similar, it requires the same type of thinking. And it gravitates, so those kind of people tend to gravitate. So Google search that. And the websites might have different sections. Like I said, Fisher Boyle is an amazing firm. It's one of the firms that I know. And they have a wide variety of attorneys that can fill that need. AVVO. It's de facto one of the best directories for attorneys. Georgia Bar. You can actually call up, though we're not in Georgia, so whatever state you're in, I don't know where you're from, but your jurisdiction likely has a bar association, and they have a section. They might have a section directory that says contracts, software, intellectual property. And they don't always say software. You'll see things that would be associated with software development, intellectual property. Because many times they might not use the explicit word software. So you have to think around the box and go, well, if it's intellectual property, if they do contracts, if they do white-collar crime, that might be the winning combo. So that, I hope that answers somewhat. Anybody else? Well, I hope I didn't bore you guys to tears too much. Thank you.